I'm a partner in the firm of Smoker, Bartlett, Slosser, Loeb, and Himes, and I'm here to represent my clients, Gary Bivens, Edward Loper, Leonard Mizio, and John Sauco, who were 4 of the original 17 mobile home owners and owners of lots, actually owners of lots, in a mobile home park called River Haven in Charlotte County.
Do you want to save any time for rebuttal, Mr. Bartlett?
Yes, I'm sorry, 5 minutes, please.
All right.
The way this mobile home park was set up, my clients owned shares in a corporation. The corporation, River Haven Inc., represented by Mr. Witt, held legal title to the real estate. The shares gave my clients the right to occupy the property and the lots. The Charlotte County came along and took a strip off the frontage of this mobile home park, known as Parcel 133, to widen Burnt Store Road. In doing so, the taking rendered 17 lots unusable for mobile home purposes. They weren't totally taken, but they were too small after the taking to put a mobile home back on it. As I said, my clients were the owner-occupiers of the lots. Actually, River Haven held legal title to the lots.
That's where the confusion comes in. Can we agree, and I think this case is kind of unique in the sense that I think everybody's proceeding that it's an eminent domain proceeding. Can we agree to set that aside? Isn't this simply you're dealing with a corporation with folks that own shares of a corporation, and this is simply a dispute between those shareholders with the corporation because of a dispute that they are entitled as a perk of certain shares the right to occupy a certain piece of land. So I think where the confusion comes in this whole eminent domain, because eminent domain is a different beast. There's a lot of different cases interpreting what's the measure of damages, but would you agree with me that this is different from that, that we're just simply dealing with a corporation, folks that own shares of the corporation with a perk that you get to occupy a certain piece of land?
No, Your Honor, I would not agree
okay.
with that. The proceeding, the way an eminent domain case proceeds to trial and the awards are determined are based upon a determination by the judge and jury, in this case because we had an order of taking and then a verdict, of what is full compensation relating to the parcel of land that is taken, irrespective of however the bundle of rights are divided up.
But you said earlier that your clients do not own. Is that you call them owners, but they don't really own the piece of land. Is that correct?
It'd be my position, Your Honor, that they're equitable owners of those lots.
And before I forget, you are in agreement. I think both of you agree that that portion of the final order of apportionment, it was incorrect that your clients did not rent the right to occupy the lot. You agree with that, correct?
Unfortunately, that would be an easy out for me because if they did rent the lots, they would be entitled to apportionment. But no, I believe the judge was wrong.
Okay,
there.
that's what I want to make sure, and that's paragraph 3 of the. All right.
That's correct. That's correct. My clients, back to your point, the initial awards that resulted from the order of taking and the jury verdict in here was an award for the entire fee, what we call the unified fee. It is determined without respect to what each interest holder's rights are to that piece of ground, okay? In our situation, then you proceed to an apportionment trial, which is where we went, and the judge is to equitably distribute the awards between the interested parties, equitably. Your analysis, Your Honor, assumes the same thing as the trial court's analysis, and that is that somehow that award, or that the order taking and the verdict, belong to the corporation. It never belonged to the corporation until after the apportionment proceeding, when the judge handed it out. In this case, the judge handed it out, ignored equitable principles, and said, that's a corporation, they hold legal title, I as a judge can't order the corporation to give away its money, and therefore I can't do anything, I'm denying apportionment. That's the wrong analysis because it starts at the wrong place. You have to go to the unified fee. That's what the awards are for.
But isn't typically eminent domain proceedings and apportionment as a result of eminent domain deal with a certain group of people, either owners or leaseholders, or it's very different from the facts of this case. Here you're dealing, it's kind of unusual, you're dealing with just a corporation that happens to own this mobile home park, and your clients get to have a share. You purchase shares of that corporation, and they don't own the piece of property. They just have
the right to occupy the piece of property?
The right to occupy.
They have the right, just like a tenant. That's what a tenant owns. They own the right to occupy a piece of property during the lease.
During the lease?
Dispute.
But you don't think that's a difference? But see, and this, we're not dealing with a leasehold, and that's why I wanted to make sure that you're all in agreement that we're not dealing with a leasehold.
I can't dispute that the judge is incorrect there.
Is there an analogy here, if this thing were a cooperative, is that a helpful analogy? Or
Yes, Your Honor. And it is very similar. I pointed the court in my brief, in eminent domain, we talk about owners in the constitutional sense. Okay, an owner in a constitutional sense is one who has the right to receive compensation. One of the classes of owners in the constitutional sense are those equitable owners. Okay, those that hold equitable title. I pointed, Your Honors, to one of this court's decisions, Mikos, M-I-K-O-S versus Kings Gate Club. It's a 1983 case. It's a tax case, no doubt. This is a tax case. The issue, however, there's a statute, Florida Statutes 320.015, that provides in part a mobile home is considered real property. Well, first of all, it says mobile homes aren't taxed as real property generally. However, then it goes on to say a mobile home is to be considered real property only when the owner of the mobile home is also the owner of the land on which the mobile home is situated, and said mobile home is permanently affixed thereto. You have to be two things: the owner of the land on which the mobile home is situated, and the mobile home has to be permanently affixed. All right. Court went on and said this was a very similar type corporation in which the Kingsgate Mobile Home Park was a corporation. It held legal title to the property. The occupiers were members. They had certificates in the corporation. Not very different from our situation at all. The court said, admittedly, no member owns legal title to the site upon which his mobile home is situated. Yet the term owner, in quotes, has not always been limited in the meaning to legal title holder. See Roberts v. First Federal Savings and Loan Association, vendee under a land purchase agreement deemed to be an owner against whom a statutory survey lien could be asserted, semicolon. Pensacola Scrap Processors, Inc. for State Road Department, holding that a tenant at will is an owner of property in a constitutional sense so as to be entitled to compensation in an eminent domain proceeding, semicolon, Wingert v. Prince, holding that a tenant at sufferance was an owner for the purpose of condemnation. Court then states, each member has practical dominion over his designated site, which is essentially equivalent to ownership. We hold that each member's interest in the site on which his mobile home is affixed constitutes ownership for the purposes of Section 320.015. That case is not on point because it's not an eminent domain case, but it is on point for the principal issue of law in this case, and that is my clients are equitable owners.
Well, let me ask you this then. Okay. Your clients lost the right to occupy that piece of property. Okay? What measure of damages, what was it that you've presented? You presented an expert.
That's right, Your Honor.
And that expert, tell me a little bit more about him. He did not make an appraisal of the property, did he?
At the point where apportionment occurs, an appraisal, his opinion as to the value of the property is not really relevant. What he has, his assignment, if you will, is to determine, present evidence as to what an equitable division of the awards would be. In this case, he sorted through the awards, of which there were a half a dozen, literally, maybe more than that totaled almost $1 million. And he said, of those awards, here's the two that go to the ownership of the real property, the loss of these that happened to my clients in 17 lot orders. And those are, one, out of the order of taking, there was a $265,000 allocation for the value of the land taken. Remember, that's only half the lot. He went to the jury verdict, and it had an amount of $270,000 for severance damages. All right? He said these two, severance meaning the loss in value to the remaining property, in this case the lots, the remaining portion of the lots that were too long.
Well, the jury made that award, and nobody really understands where they came out of that. I mean,
That's
would you
correct.
agree with that? Okay.
That's correct.
Okay.
But
you have a certain amount of money. Okay.
Those are the two elements that related to what my clients lost. The business damages, they didn't lose the business damages. The replacement in water and sewer, they didn't lose those things. Those two elements are all he considered. He then reduced those awards by the amount of land that was taken, which was outside the lots themselves, to come to a per lot value that were given by virtue of the order of taking and the jury verdict, and then divided that by 17, except for he reduced it by 1%. It was his opinion that my clients, not being legal owners, but being equitable owners, were entitled to, had almost all the bundles, all the sticks in the bundle sticks.
But did it, and if you multiply that out, wasn't there, it was argued, I think, by the other side that that really is an unreasonable amount, because if you multiply that to the number of folks, it would come to a much higher number than what was awarded. And having said this, couldn't the judge properly, he's sitting as a trier of fact, can he say, I reject that testimony because it's incredible for me to accept that testimony?
No, I don't think he could do that.
Okay, tell me why.
Because the only other alternative in front of that judge was zero. First of all, the $29,133, which is what the expert, Mr. Haynes, testified to, was in the range of values of the other lots he looked at in the area that had similar amenities. So that was really appropriate value of the lot. Second of all, if you multiply that by the four folks who are left, that means that the Riverhaven Inc., the corporation, was still would be awarded $850,000. It wasn't incredible at all. Now, the fact that the corporation decided to put on a certain way of calculating their award at trial should not be held against us as owners of those lots.
Whose burden, do you bear the burden of proof to show as to what, who bears the burden of proof in this case?
I looked at that. There's not a case on point. It is my motion. It is my client's motion. Typically, when I have to bring a motion, it's my burden of proof. However, in this case, since we're dealing with an equitable action following the jury verdict, I would argue that there really isn't a burden of proof. And what we're dealing with is an equitable division of a pot of money. And the sides have equal opportunity to make an argument. It's not that one gets one number and, you know, the burden goes the other way, you get a zero. The judge really has the right to...
Which leads me to this, so what would be our standard of review?
Your standard of review?
Yes, sir.
This is a mixed question of fact and law. With respect to the issue of law, specifically the application of the corporate law that the judge made, and which I have argued is erroneous, there is no deference given to the trial court. It is a pure question of law. With respect to the evidentiary question, which Your Honor recently alluded to, which was what evidence was put before the judge, and I think that's your substantial competent evidence, of which I would argue and did argue that the only substantial competent evidence of value for these equitable owners was presented by Mr. Haynes. The mathematical arguments that Mr. Witt made at the apportionment hearing are not evidence, one, they're arguments of counsel, and second of all, they're not appropriate because this is an equitable action. It's not a mathematical action. You don't get to say, all right, there's 144 lots and we should divide, you know, $990,000 evenly. It's not what happened. We have 17 folks who lost their property. They are equitable owners. They are entitled to constitutional guarantee of full compensation. As of today, they've got nothing. They lost their property. They
still have the share? They still have the shares?
They still have their shares. They're worthless. They still have them.
Mr. Bartlett, you're into your rebuttal time. You can continue or maybe the rest
Oh, I will sit down right now. Thank you, Ron.
Good morning. I'm Michael Witt. I'm with the law firm of Becker and Polyakov. I represent Riverhaven, Inc. Judge, you raised a very good question and made a very cogent comment. This is a very novel case. Those of us geeks that practice eminent domain law and you know, look at all the cases that come out, this is going to be an interesting decision. Let me start my comments by saying I agree with your questions to Mr. Bartlett. We can just lay that aside about the paragraph 3 of the order on apportionment, it being rent. It's not rent. They're maintenance fees that are being paid. Let me address for the panel the issue of ownership, quote unquote, equitable ownership by these, what started out as 17 affected shareholders now remain 4. 13 of the 17 had their homes purchased by the county. They redeemed their shares to the corporation. They've moved on with their life. There were 4 that were remaining, participated in trial, and filed a motion for apportionment. Based on the questions, it would be easy for me to stand here and say, gosh, you know, I can press my advantage. It sounds like, you know, some really tough questions to my colleague. But I want to make sure that the court gets this right. As I said, if you review the transcript, as I argued to the trial court, under the Micos decision and the Nordbeck decision, where the court in an ad valorem tax issue wrestled with the question on whether mobile homes in parks such as this, where they do not own fee title to the property, but they own a share in the corporation that owns the fee, and they have their home place there under Article 7 of the Florida Constitution for purposes of homestead exemption, are they deemed to be owners? And the court, second DCA, ruled in both of those cases, yes, indeed, they're owners. I believe that the law is fairly broad and favors a finding of affected property rights, just generally in the constitutional sense, in the eminent domain context. And as I argued to the court, let's answer that question first. Were these 4 appellants equitable owners of property within Riverhaven? I think under the controlling law in the 2nd District, under Micos and Nordbeck, and even though they're tax cases, they're so similar to the issue that I think that the court should follow that. And they should be deemed equitable owners of property. But that's just the first question. If they are, they would be entitled to some compensation. But what? And how much? That's really where the question that was before Judge Foster started meeting a lot of different arguments and theories. Let me just put this forth as we argued to the trial court. I think there are a few steps, a few building blocks, but I think if you follow that, then you come to the right answer. I think the trial court almost got it right, but I don't think that Judge Foster got it right. And here's why. It should not be a zero. If they own property, and they're an equitable owner, they have a property interest under 73, I think it's .061 on apportionment, they're a, quote, interested person. But what do they get? You have 0, and you have $29,133 that the appellants asked for. The 0 came from the testimony of William Reeve, our appraiser, who said, look, they don't own the fee. I don't think they're entitled to anything. They own a share in the corporation. As an appraiser, what I have to do in appraise to say, what would the value be to them? I don't think it's anything. And I think that's legitimate.
And you know what, Mr. Witt, if I
Yes.
may, because that was the question that I've asked in terms of who bears the burden of proof.
Yes.
I'll grant you this. They've lost something.
Mm-hmm.
What is that measure of that loss? So who bears the burden? They bring an expert before the court. The court could properly, if the expert is asking for the moon, and the court doesn't agree with the moon, what is the court left to do? So who bears the burden with that?
I don't know the answer to that. I wish I did. And as Mr. Bartlett pointed out, I've looked at that issue, although not exhaustively, initially going into the apportionment hearing. It's the burden on him. It's his motion. I really couldn't find any cases. It didn't come up in the trial court context. Not an issue on appeal, really, who bore that burden. Let's just assume that it's the burden of both of us there to try to present our case, and the judge, as Mr. Bartlett pointed out, there's a finite pot of gold in front of him to say, now, how do we divide this up? The first question is, are they entitled to anything? Are they an interested party? Do they have any interest in the underlying real estate? As much as I'd love to say no, and that would be a great benefit for my client, I think the law is yes, they were an equitable owner. Now, trying to get to that number, okay, again, you had 0. Don't think 0 is the right answer. 29,133, I feel very strongly that's not the right answer. And I think this is where Judge Foster was on the right pathway, just diverted a little bit in his analysis, which led to your questions, Judge, about isn't this really just a dispute under, corporation where you own a share and all of that? Yes and no. Here's the way I see this, and what we presented to the court. And we had Mr. Reeve testify. I think if you go back and look, there's sufficient testimony before the court through Mr. Reeve about values, even some of the testimony by Mr. Haynes. I think this is really, since you're dealing with that pool of money, it's not so much what you typically see in an apportionment case with what's the appropriate capitalization rate to apply, in an instance where you've got a lessee seeking an apportionment, something like that. This is really a twofold question. Should they get a portion of the $265,420 that was the land value, the stipulated land value, what I call the dirt value, the dirt price that Riverhaven was paid for all of the real property that was taken? Mr. Bartlett argued to get to his higher number, they argued at the trial court level, it should include the $272,000 for severance damages. I disagree with that. And really the reason I disagree with that is pretty simple. If you look at the jury verdict, they awarded $272,000 for severance damages. That's it. We asked for substantially more in severance damages. They awarded $272,000. Mr. Haynes was making assumptions. I objected, and the court sustained that at the apportionment hearing, was making assumptions about, oh, well, it had to be for the non-economic remnant, what was left of those 17 lots. Well, not so fast. We also asked for a bunch of money for other impacts, including noise, and we have since built a noise wall, if you will, about an 8-foot block wall. That was included in the record, the photographs of the wall. So money that was received for severance damages by Riverhaven, a substantial portion was spent on putting the wall in. We just don't know what the jury awarded. I think you have to set that aside, and I think really in this analysis you have to say, how were they affected? Their homes were purchased, so the two that had homes, they got money. The two that didn't, they didn't have a home to buy, so they didn't get anything. It's the loss of the use of that strip of land. It's the land value, $265,420. What we said to the court, and Bill Reeve, the appraiser for Riverhaven, testified, never in a million years would you divide that by 17. The 17 were merely shareholders, like all 144 were shareholders. You would divide that number from an appraisal standpoint, you would divide that number by 144, which would give you $1,843 per lot. That's what that land value would be. And then they would get, if that's the analysis and they were affected as to their lot, that's what they would get, or at least that would be the starting point. Do they get 100% of that lot value since Riverhaven had the underlying fee? Do they get a portion of that? Whatever. That number is fairly minuscule. I mean, let's face it, $1,800.
Let me ask you this.
Yes.
Was there? I assume that these certificates of stock or whatever they are transferable.
They are not.
They're not. So
no, they're not.
You can't sell your mobile home?
You can sell your mobile home. When you sell your mobile home, your shares get redeemed back to the corporation, and the new mobile homeowner goes to Riverhaven and gets new shares. Whether they want 3 shares, 5 shares, 10 shares.
Can they buy them?
They can. They're required to buy shares.
Okay, so is there any evidence about what the shares are redeemed for, or what you buy them back for?
I don't know that was in the record in front of Judge Foster. It clearly was in the trial court record. It's $1,000 a share, and at the time, the relevant time, the minimum that you could hold was 3, the maximum 10. And that's where we kind of get with the per share allocation, and it was a stipulated fact. As of the date of the order of taking, which, as you all know, that's the key date in these eminent domain cases, there were 1,138 outstanding shares.
So we're talking about a lot value. You
yes.
argue that we're talking about a much smaller value than $29,000.
Yes.
Some figure like that.
Yes.
Is that correct?
Yes. Well, yeah. If you, as I put in my brief, equity abhors an absurd result. I mean, you can't get to an absurd result. That's absurd. That's an absurd number, and I use that term because that's kind of a term of art under the law. If you just apply simple mathematics to the $29,000 number, let's run it 3 ways. 29,000 times 4 is, I think, like roughly 116,000. They're going to take 4 people are going to take about 50% of the entire number that would go to 144 lot owners, okay, if you use the $29,000 number, okay, just 29,000 times 4. If you use 29,000 times 17, that comes to $495,000 and change, which is double the entire land value number, okay? And then here's one of the critical facts we put in the brief. If you multiply and use that number, 29,133 times 144 lots, that means that all the lots in the property within Riverhaven, really excluding the common areas, but all of the lots there, that means Riverhaven would be worth $4.3 million, just using that per lot number. And both appraisers, the appraiser for Charlotte County and our appraiser at trial, that Mr. Haynes, their appraiser, relied on their appraisal reports, they both valued Riverhaven at around 2.3 to 2.4. It's almost double the value.
So
you can't have that number.
If I may, Mr. Rick, having, and we recognize all that, but the bottom line, I guess my question is, the judge heard this, rejected that, came to a conclusion that's really not supported because there's some value. Who bears the burden? If it's the appellant's burden, what is it? And what's our standard review? Do they get another chance to put in other evidence? Do we? That's the dilemma that's in we're dealing with. You've mentioned about shares and a portion of the shares, but this is the problem with respect to how this case materialized.
I appreciate your question. Let me try to answer it by answering the next question in my building blocks, because I think it directly affects that. Having this pot of money there, then $265,000, I think it's really almost a question of law for the court to look at, to say, can I treat these 4 shareholders different than I'm going to treat all 144 other shareholders? That's how the judge got to a 0. And because he answered that question and said, no, I can't treat them differently than the other 144. Riverhaven has not made a distribution to all of the other members. I don't feel that I can order them to distribute this money. So unless they distribute, they're going to get 0. However, if you distribute, they would get their share.
Nobody would argue that the 4 people that Mr. Bartlett represents haven't had a far more adverse consequence than the other folks, right?
No, I would far more adverse. No, maybe slightly more adverse. Yes. Look, you bought out.
Lost the place to put the mobile home.
Well, yes, but the other people that own in the park, they lost a substantial amount of their park. I mean, in the future, if they go to sell the park, now they've got, it's 21.3 acres. They've lost about 10% of the overall land mass, of the property. Where they were impacted in a number of different ways in the park. It's not like it just affected these 17 lots. Otherwise, we would have been dealing with $265,000. That would have been it as far as compensation. There were all kinds of other issues. Let me, in my time remaining, just try to get this last point, because I think this is where the court almost went, but didn't, and probably should have. $265,000. One of the ways the court could have carved that up, as testified to by Bill Reeve, was you just divide it by 144, $1,843 a lot. The court said, no, I look at it with, I don't think I can treat them differently. If this were going to be divided up, I think it would be divided up by shares, and I had cited the court to Chapter 607, I forget the exact statute, I cited it in my brief, that deals with this issue, corporate distributions. Here's where I think the court maybe was wrong. Where the court said, I can't force Riverhaven to distribute. I think the court had the inherent equitable power to say, I've got this pot of money, and the remaining 127 homeowners in Riverhaven are going to benefit. The Riverhaven Corporation has this. These 4 people will never be able to benefit from that money. They're gone. They've moved, their homes have been purchased, they're gone. And I believe that they would be entitled to their share. Now, the judge said if we ever distribute in the future, I don't think the judge could really order that. You know, what do you do in 10 years when we're sitting on cash and we decide to make a distribution to all the shareholders, and then they come back and say, oh, that was the award money from way back when. You know, how do we even know where they are? How do we track them down? But I think what the court should have done is, I think the court should have said, you can't be treated any differently than anybody else, okay? Yes, you were affected. Yes, your home was purchased. Yes, you're no longer living here, although there was a fact that was presented. There were other lots within Riverhaven. They could have moved their home, you know, had they so chosen. Some of the 17 did move to other lots within Riverhaven. I think the court should have said, you either get $1,843, that's it, or we do the simple mathematical calculation, 265,420 divided the number by the number of outstanding shares, gives you a per share price, and then it's a matter of multiplying it by the number of shares that Mr. Bivens, Mizio, Salco, and Loper owned. And that's what we presented to the court. Yeah, and I'll just make this last point. Either way, some of the 4 are going to be unhappy because, for example, because they own different numbers of shares. So if you go with an $1,843 number, Mr. Mizio, who owns 10 shares, he's going to end up with a little bit less money. And the others who own 3 shares, they're going to make a little more money than they would on a per share basis. I don't know the answer. There's no law on that. I mean, you know, in an apportionment proceeding, there's no law. But I don't think we have to go back for a new hearing. I think it's a simple matter for this panel to say, in an apportionment proceeding, they're an equitable owner. Are they entitled to something? You betcha. Should they be treated any differently than the other 144? No, because everybody owned Riverhaven. Everybody owned it according to the number of shares that they had. And should they receive a distribution now, even though there is no distribution made by Riverhaven? Yes, because they're not there anymore. Who gets it? Not the 713 who have redeemed and who are gone, but the remaining 4. Now the question to you is it a per lot, or is it divided on a per share basis? Personally, I believe it is a per share basis under Chapter 607. That would be the calculation that this court should say. You know, go back, judge, this is the number, here's how it's done. You know, and the analysis, you know, just like I said, the building blocks, you know, going up, you know, to come to that conclusion. Any questions? Sorry to make your heads spin.
No,
but
I guess, Mr. Wood, because what you're asking us to do basically is to reweigh part of the evidence, obviously take into account the court rejected certain evidence, then you're basically asking us to take other evidence, come to our own conclusion. There's no cases supporting this. It's a troublesome request.
And I know I'm probably over my time. If I may, let me address that.
Just going over. I'll give you a minute.
Okay, thank you. If I can address that question. I wrestled with this when I wrote my brief, the standard for you all to look at, and I, you know, the most of this I think is the court weighing facts as to, you know, what they should receive. But I was probably equally torn by, as Jay said, it's really kind of a mixed question of fact and law. On the question of fact, I think that's pretty easy. I don't know that the appraisers really added that much to the mix. I think the court is looking at a finite amount. I think the fact question would be, you know, can you look at the jury verdict and include the 272 or not? And if it's 265,420, that's easy. It's divided by 144. And I really think that that's almost like a question of law for the court to say, can I treat them differently under the law? Are they an equitable owner under the law? Yes. Can I treat them differently under the law? No. And as such, then, there's really no law and no guidance as to per lot or per share. But I don't think it has to go back and we have to have another fight. Nobody can add anything to it. Here's the pot. It's either per lot or per share. That's it. And I think that could be in your order, or if you send it back with the direction to the trial court to say, this is how the final judgment should be entered. Here's our finding as on our review of the facts and our review of the law. Thank you very much.
Mr. Witt, Mr. Bartlett, you had 5 minutes left. I gave Mr. Witt additional minutes, so I'll give you 1 more minute if you need it.
Thank you, Your Honor. I'll try not to use it all. Judge Gazal, when I finished, the last thing you asked me was, don't they still have their shares? Yeah, that's not what was taken. What was taken was their right to occupy the property. And that issue really ties into all the corporate law arguments that Mr. Witt was making. This is not a corporate case. The shares weren't taken. The corporation is still there.
And I agree.
It's the dirt that was lost.
And I agree with you that your clients, they've lost something. What is the value of that loss? And that's where this whole issue becomes murky.
Well, here's an easy way to look at it. If Riverhaven agrees that it's not zero, what other substantial competent evidence was before the court? $29,133. That's what it is. There's no burden argument. If it's not zero, that's the only other thing it can be. It's not a division of corporate assets. It's not a forced distribution. That's not where we are here. Remember, the valuation, the awards, was of the unified fee. The unified fee. The court then is supposed to spread out the interest and assign numbers
Let me
to
ask
this.
Assuming that we have all the evidence we need, and the trial court used a method of calculating that was legally incorrect, why can't we make the determination ourselves as a question of law, or do you disagree with that?
I've got to tell you, I'm uncomfortable with that. It sounds like a factual determination to me. I'd like to agree. I really would. I just don't know the answer. I don't know the answer to that. I've always been under the assumption that if there's only substantial competent evidence to support one side, then you've got to go that way. I have not looked at it as in terms of this court being able to divide an award based upon the evidence below it. But I can tell you that the evidence is there. The problem is you don't get a live look at it. And I think that's a problem with having a panel make a determination about it stale, as they used to say, a stale record. You don't get to look the witnesses in the eyes and those sorts of things that happen at the trial level. And
So would it be your position if we decide that the trial court's got it wrong, we need to send it back and have a second evidentiary hearing on this? Is that?
I really don't want to agree with that, Your Honor.
It sounds like that's what you're saying.
I think that's my legal training. I don't know of any case that would allow Your Honor to do that.
To do which?
To make that determination yourself, unless it's one of the two positions provided down below. Again, the division based upon either number of lots or number of shares is not equitable in nature. There's no doubt that my clients were one of the 17 that were more severely affected than the others. The award doesn't go to the corporation and then the corporation gives some of it away. That's not what it is. The awards go to a registry, and then the judge is to divide it out. The corporation never has to distribute it. It should have never been in the corporation. Okay, that's the distinction. It's not. That's why it's not a number of shares or number of lots or anything. It's what they lost. And what they lost, what my clients lost, they lost everything. And at this point, they've been deprived of their constitutional guarantee of full compensation. I'd ask Your Honors to overturn the trial court's ruling and award each of my clients $29,133. Thank you.
All right, well,
Thank you.
thank you both, gentlemen. This has been interesting, and I think we understand the problem better now than when we started, so we appreciate your help.
Thank you.
All right, we'll take up the last case, which is Wilson versus Cornerstone Developers.